Welcome to the Kentucky Auto Accident Podcast. Louisville attorney Jim Desmond has been handling injury cases related to traffic accidents for over 20 years. Jim will provide valuable information to help you and your family. He wants you to understand the important issues you need to know when it comes to handling car accidents and motorcycle wrecks in Kentucky. There's a lot riding on this, so let's get started. Well, we're back in the studio with Jim Desmond. Jim, welcome. You've had an interesting week or two here.
I have. It's been kind of fun.
Well, I tell you what, you kind of stirred the pot a little bit. You drafted a blog post that's called "Don't Trust the Television Advertising Attorneys," and that went live on your website earlier this week or late last week on attorneydesmond.com. And that kicked up some responses, obviously. Probably a few from your peers, but at the same time, a few from people who may have read that. Let's talk about what compelled you to write a post like that.
Well, I mean, and it did give some responses. That was the interesting part. The scenario that started it all off was I had a phone call from a lady that she didn't have car insurance. That was the bad thing. But she was told by, and I won't say the names, but two firms that advertised on the television, okay, that she didn't have a case, all right? And I knew it didn't sound right. She had surgery involved, and liability-wise, I think we could prove fault on the other driver. So the short story is I met with her, got the police report, and we got the other insurance company online. Case is still ongoing, but yes, it looks like, one, she has a case. Two, it looks like it's going to be a pretty fairly significant recovery from a case that other people said no. She had no case. She had no ability to recover, and they passed on it.
And she wasn't just told by one. She was actually told by two different firms.
Right, and that's the bad thing is that, she's sitting here thinking, I don't have a claim for the damage to my car, my medical bills, or, the pain and suffering, any of it. Because, again, she thinks she's calling people and getting a competent answer, and she's not necessarily.
Why do you think this happens? I mean, obviously you're not going to talk about, a colleague. You're not going to talk about something else like that. But in general terms, what do you think answers like that are given to people?
Well, and on that issue, I want to be clear. I used to work with one of the big TV advertisers till 2005. Anybody who knows that knows I put about 4.5 years into one of them. So I know their procedures. And I am not negative on their attorneys, okay? I know people that are over at the big TV advertisers that are very good, very competent attorneys that either, one, I've worked with over the years, or two, we've been co-counsel before they went there. So I'm not bad-mouthing the attorney per se. What I'm saying is the procedure, though, that is set up is the problem. If you have this huge law firm that brings in all these cases, okay, attorneys have certain capabilities, and we only have a certain number of cases we can competently handle. When I was at the old firm, when I first came into that big TV advertiser, I had 400 files, okay? So that meant I had four paralegals with 100 files each reporting to me, and I had 400 in total then. So again, you can't give it the same attention you could if it's just an individual. The problem that I'm trying to make with that blog, and that was where I wonder if I did so successfully or not, I'm not saying you can't get good advice from another attorney. I'm worried about the procedure that's set up in that will your case and your claim get to that attorney so they can actually tell you what's right or wrong and the strength and weakness.
And I think that's the point right there. A lot of times in these kind of setups, you're not directly speaking with an attorney, at least not after the first handshake or whatever. For the most part, it's being handled by a staff member. Is that correct?
Correct. That's the problem. Let's go back to the case I just signed up. Okay, and it's going to be a nice little fee for me, and she's going to be happy and everything else. She being the client. I guarantee you, it did not get past an intake person or a paralegal. All right, and I'm not trying to down paralegals, but look, attorneys are attorneys for a reason. And, I always said, even among attorneys, I've told you people in the past through these podcasts or blogs, I've said, look, car wrecks are the most lucrative area out there. I don't pull anything about that. I just say it. It's true. It pays more than any other area of the law. So a lot of people want to do it. But again, if you don't do it regularly, you don't know all the ins and outs and all these little tricks here and there and things that can add up. So not only do you want to get to a competent attorney, you want to get a competent attorney that handles car wrecks. And if you're making a phone call to some firm that's fielding 20 cases an hour, I don't think you're going to get the same attention you need from just, a smaller firm, a smaller attorney that will talk to you individually and say, this is why I think you have a case, or this is why I think you don't.
Right. And, one of the things that I hear on TV or that, is often out there is, well, we've got all these resources. We've got all this ability, to really fund this case. And, well, yeah, but they've also got other budget constraints that make them have to choose their cases a little bit differently than you might at a smaller firm?
Well, and the resources issue, I mean, first of all, that doesn't do you any good unless you get to the attorney and get that attorney's attention, okay? If you're one of 10 cases and you have a great case, you're out of those 10, you're the best case. It doesn't do any good if he doesn't know about your case. Another thing is resources. I mean, attorneys in general, I think, are very competent in a lot of ways, and they know how to compensate for any issues like that. For example, we just settled a small case, okay, that, again, it was going to take more time than I had to work with this one company, and I don't like the defense counsel. I'll just be upfront. I won't say his name, but so I pulled in somebody as co-counsel. And so, again...
So you basically went out, you have another attorney working on the same case with you, co-counsel.
Right. Okay. He was doing more frontline things. I was doing more backline things. Okay. So, again, there's ways to compensate, again, for the what they call resources. There's plenty of... I always say to people, again, pick up the phone and call me because... there's 3 or 4 attorneys that I can call or send an email to that I work with regularly over the years that I would trust with my own case that I can say, look, am I seeing this right? Am I wrong? Or do you have a better angle on this? Because, again, we don't want to believe our own hype. But, no, I do not agree with this malarkey about, okay, we've got these resources, because what you've got is this huge machine that you continue to try to push down the road. Well, again, the only way you do that is by keeping the cases coming in the door, and that they have to be settled within a certain amount of time and go on to the next one.
Well, and you and I, as we prep for this, we're talking about, if you're in a minivan and you get hit by a giant semi-tractor trailer and there's all sorts of problems, that case is going to get some attention.
Correct.
And that's going to get a lot of the resources because it's going to take a lot of the resources. But a fender bender down on Bardstown Road or down on Broadway is a whole different game.
Right. And again, you have to have somebody who's familiar with the facts and reminds themselves of the facts, because let's face it, okay, even there, you talked about fender bender, and what I was thinking is, okay, typical fender bender in Bardstown Road, let's say it's a $3,000 to $8,000 case, okay? Add in that person was hit by a drunk driver, okay? Take that value, add $10,000 or more to it. So, again, you want your attorney to be aware of all the facts, and sometimes you want to be able to remind them, all right? We're busy people. I'm not going to deny that, okay? So I don't mind it when a client says to me, hey, by the way, did you do this or that? And I'll make notes to myself or on the file because, again, there's little issues that we want to make sure we put in front of the insurance company. A lot of things, we talk about this whole process and realize something about a personal injury claim that we've talked about in general over the last several podcasts. A lot of it is taking a whole lot of pieces of gum and throwing it to the ceiling and seeing which ones stick. So, again, the more pieces you have, the stronger they are, the better you want to do it. But, again, you don't know that, and you don't know what to do unless you're in contact with your attorney. If you're I had a gentleman I just signed up, and neck and back strain. But, again, he's, I think, 6 weeks after the accident. He's got knee pain and nobody's looked at it. And I'm like, we need to get him to see an orthopedic because, again, he might have a meniscus tear or something else. You want that guidance, and you get that guidance how? Not from a paralegal, not from a secretary. You get it from your attorney who has a game plan in his head saying, this is what I want to do to maximize the odds that this case is either going to, 1, resolve for a good amount without litigation, or 2, that I have the best case I can put forward in front of a jury should it proceed to litigation.
Well, and that's the thing. People kind of focus on neck and back. Okay, that's pretty important, and that gets a lot of attention. But a knee, a lot of times in a collision, the knee hits the dashboard. The knee could have been, banged up against the side door, a number of different things. But it's still a phase of the injury. It's still a part of the injury here that, like it or not, has value. And obviously, right, it's painful for the client, so they want compensation for that as well. They want that to be taken into consideration.
Well, and that's the thing that runs counterintuitive to what we know, okay, in the sense of, go back to one of the principles I've said before in the podcast, cases live and die on the medical records. Yeah. Well, when you go to your doctor, you don't generally want to say, give them a laundry list of 10 things. You tend to minimize it, and you concentrate on the main things that are bothering you. From a car wreck standpoint, a personal injury claim standpoint, it's the opposite, which is you basically want to list anything that is bothering you. And the reason you have to do that is not only does it affect the value, but again, okay, if this knee had not been brought up, okay, and I had these kind of cases before. So they treat for the neck and back. We're not settling the case till 9 months, down the road. Well, I find out at 7 months he has a knee surgery. and I'm looking back in those medical records to see, was there any complaint of knee pain? Did it hit the dashboard like you just mentioned? Something to substantiate it, because otherwise an insurance company is saying, hey, we didn't know anything about this knee, and we didn't plan for it. And what makes you think it happened this way rather than when this gentleman lifted his kid too quickly or tried to do a squat or burpee or something like that?
Could have fallen down in the garden or something.
Exactly. And that's the problem you face. The thing that people want to understand, and we're going to get into the COVID part too now because it's all the more true, is that, again, when that accident happens, everybody wants to just go on and say, okay, accidents happen, everything. And I get it. And I don't blame you, and I understand that. But the reality is when that accident happens, from minute one, you're starting to make and plan for your whole possibility that you're in front of a jury 2 years from now, whether it's to recover for the damage to your car, your medical bills, or your pain and suffering. And that's the part where, again, I've said before, if you're at an accident scene and you're not hurt too badly, pick up your phone and take photographs again. Notice the video cameras around there. All this kind of stuff that sounds so crazy, but otherwise you get stuck in a case where either one, somebody doesn't believe, you're not at fault, and they may not believe your injuries depending on how you did it. Or two, you're sitting here, in a case that you didn't even want to proceed with, but they made a claim against you or claiming you're partially at fault. So,
right, because Kentucky is comparative fault, right?
Kentucky's what you call pure comparative fault.
And how does that come into play for an auto accident?
Well, and actually, I'll give you an example of that. I think I'll talk about this one because it kind of illustrates everything. You don't even know about this case yet, Jim. I took one in that there was a good argument that my client was the majority at fault for a wreck. Okay. So, but I think there was a good, strong argument the other person was driving excessively. So the short story is we succeeded in arguing that other person was at least 20% at fault. Well, we always talk about, you've heard me 100 times preach about policy limits. Policy limits on the case were only $25,000. We had $100,000 in medical bills because she had a hip surgery. Well, back to using health insurance, okay? The health insurance basically took that $100,000 in medical bills and, believe it or not, paid out $9,500 to satisfy those bills.
Wow.
So they had a right to recover the $9,500. We got that reduced even a little further, okay? And at that point, basically, we got it resolved because, again, if you take 20% of $100,000 plus the pain and suffering claim, you're already in excess of that $25,000 policy limits. That's what you're talking about with the comparative fault, which is you can recover up to 99%. Well, you could be at fault. Let's turn it around. You could be at fault for a car wreck, up to 99% at fault for a car wreck, and you could still recover 1% of your damages. So if you lose your left arm in a car wreck and a person has $25,000 in insurance and you were at fault for the accident except for that 1%, you could still potentially at least recover that $25,000.
Right, and these are the things that people, in theory, it sounds good. Yeah, I don't want to sue. I don't want to do this. I don't want to really pursue this until the bills start coming in. And if you haven't documented, the issues in the case and things like that, I mean, you're at a disadvantage for something that probably wasn't your fault to begin with. I mean, it's just a fairness issue to me.
And that I agree with, because I think even if, no matter what, even if you say you don't want to do a claim for pain and suffering, well, the claim for pain and suffering, part of the components are lost wages that you experienced, as well as medical bills and copays and deductibles. So the problem is, even if you weren't at fault for an accident and you don't want to proceed with it, you're still going to be out of pocket to get back to the ground zero. But the bigger thing I want to go back to is let's get you educated on what those rights are, and then you decide. Right. You see what I'm saying? Because, okay, fine, you say you don't want to necessarily do all this. Okay, let's do a quick phone call and talk about time limits and using your health insurance, for example, in that case, rather than the no fault or PIP coverage that would have been exhausted immediately otherwise. All these little pitfalls and stuff. Let's get you on track, and then you can decide what you want to do with it down the road. But again, how do you get on track? You don't get on track, and I'm going to get in trouble, and I'm going to get phone calls from paralegals and secretaries. You don't get on track from anyone but your car wreck attorney that you get direct advice from, who says, this is how we are on track, this is what our game plan is, and this is what we want to do. And you can't do that unless you can get that person either on the phone or have them meet with you. I'm gonna do a 2-minute rant like you've seen me. Jim Ray is smiling across the thing for me. I have said something to you guys 100 times over, and anybody who's called me and wanted to fire an attorney, I've said the same thing. if we're typically, and actually you bring me up fees in a second, but typically we're charging you at least 1/3 of what we recover. You're going to pay that 1/3 no matter what. So again, if you can't get that attorney on the phone, then you call his secretary and say, I want to sit down with you and go through this case for 30 minutes to an hour, okay? And I want to know what your game plan is. Because you're not paying any more for it. Why wouldn't you get the best bang for your dollar? Another little side note on that Jim's sitting here saying we're going off script, so to speak, even though we're not tightly scripted. Again, a lot of these bigger firms are starting to charge a flat fee of 40% pre-litigation. Wow. And then higher for litigation. I think that is insane. I would not suggest you do it because, again, if you think about a case, let's say $100,000 recovery on a case. If you're without litigation, automatically at 40%, you're at $60,000 of that $100,000 is all you're going to recover. Okay, now you reduce that by your health insurance lien and your unpaid medical bills. Okay, you have a potential that you're now going to be pulled, below $50,000, maybe $45,000. So again, you don't want the lion's share going somewhere else. Yeah, and as I've said before in a podcast, and I use this phrase with all my clients, good personal injury attorney, the job is get you as much as they can with the right hand and keep as much of your settlement from going to medical bills and other things, health insurance liens, with your left hand. Those are the two things.
And that's knowing how to structure the negotiation, how to get one person to move before the other. And that's how you protect that client, is really managing that, because there's a lot of stuff that's going to come at them quickly that if they're not prepared for this, and most wouldn't be, I mean, how conceivably could you actually try to handle this? You can't. Yeah, you really can't.
Well, and I think you're getting at something else here that, we've talked about before. Think of your personal injury attorney a little bit like your computer, and the old phrase on computers is garbage in, garbage out. Okay. Mm-hmm. Again, the sooner you talk to a good attorney and get a game plan, the better. Okay. Because, when you said that, I was thinking of it. I have another case right now where I have a lousy first offer, justifiable, but a lousy first offer.
This is the insurance company of the at-fault driver.
Yes.
Giving you guys an offer, hey, will you take this?
Yeah, and it's not a good offer, but then again, my client waited a little bit on treatment, so I understand why they're doing what they're doing. Well, the short story is the no-fault coverage wasn't exhausted. So sometimes you can do this, sometimes you can't, but I grabbed the no-fault money because, again, if I have that and I can get some doctors to take a little less, and I get the insurance company to make a better offer, you put it all together, now all of a sudden, boom, you got a halfway decent offer where the client's happy. You follow me?
Right.
But you can't do that unless you do that early on and have an idea. If you wait, I have another case that that a very nice lady, I think I met with her probably 4 weeks ago, very nice, very competent, handled it really well for the longest time. But again, her no-fault coverage got exhausted, and had I had it from day one, I would have reserved it and used it to pay either the health insurance lien or these other co-pays and such. So there's a different game plan, depending upon the case. But again, how do you know that game plan? It's not that you don't have good, competent attorneys in different firms across town. It's that you have to talk to your attorney directly, and he or she should be able to lay out a good, competent game plan for where they want to take your case. Is it always going to work that way? No. Just like the case I just told you about. I did not expect such a low offer, okay? But now I've got at least the means, because they came to me early, of trying to pull a rabbit out of my hat.
Well, and that's, at the end of the day, everybody's case is unique. The facts of this case are different from the facts of any other case. So again, if you take a template approach, just because we're cycling through so many cases, we don't really have time. This is how we do it. It's going to be a little bit different in terms of what you, as a solo practitioner, this is your firm. You set the rules for your firm, and you handle the client the way you want to handle the client.
Right.
And so I think the approach might be markedly different.
Well, and part of that that's twofold. The first part of what you were just saying is, okay, let's face it, as a solo practitioner, if you get a policy limits case of $25,000,
and policy limits again, the other driver had $25,000.
That's all the insurance the other driver had. Yeah. So can you sue somebody beyond their insurance coverage? Absolutely. But is it worth it? No, because you're trying to collect against things with wage garnishment, bank account garnishments, all this crazy stuff.
They may not have assets to begin with.
Exactly. So, but if you get a policy limits offer of $25,000, okay, your attorney's fee is $8,333. Okay, if I'm always well aware that if I pull in an $8,000 fee, That's what some people make over 2 or 3 months, okay? A big firm, advertising firm, they might spend that for lunch hour, okay, on the TV commercials. So it's a big difference in perspective. As I've told Jim before, my philosophy is always you want to be the big fish in the little pond versus the little fish in the big pond, because I think you get more attention. And you said about every case is different. That's again, I mean, that's why, and I've said this before in other podcasts, I tell one of my clients when I first sign you up, don't listen to Johnny wasn't hurt and got $25,000 because it doesn't happen. Don't listen to 3 times your medicals. That was a formula that existed in the 80s, okay? Every case is different. It depends on the facts and the circumstances. And is every case worth pushing? No, they're not all. And I will counter something else. Everyone wants to act like personal injury is all about trying to get a lottery ticket. It's not. It is 9 out of 10 of my cases, it's about keeping that client from going backwards from a car wreck that wasn't his fault. And what I mean by that is the lost wages, the fact that he's going to buy a new car that his other car was paid for, and now he's stuck buying a new car because the law doesn't cover replacement value, only fair market value of the vehicle, okay? And so now he's stuck with a car payment or the co-pays and deductibles from the health insurance, or scarring. And 9 out of 10 times, that's the stuff we're dealing with. I've never had I've had clients very pleased with what I've succeeded in doing, but I have never had somebody come back and say to me, woohoo, this was worth it, this was great. It's like, no, it's not.
It's a tough process, and it can be a long process.
Right. Yeah. And it's a lucky process, because go back to the other issue, which is, as I've said before in different podcasts, you lose your left arm in a car wreck and, it's a big semi-tractor trailer. Okay, we got enough insurance coverage. That same accident happens and, it was a kid driving a 1980 Toyota and we're in trouble.
Yeah.
So.
No, that it's tragic, but it happens all the time. Let's talk, with the coronavirus and this COVID-19 thing. I mean, obviously the process has slowed down, but claims are still being filed. I mean, this is not something you want to wait on. I mean, you're still obviously answering the phone. Right. The insurance companies are still working. You want to talk to us about how the process has changed a little bit?
The biggest thing is it has slowed down a lot. I've still been answering the phone. I've still been talking to clients and meeting with them. Of course, we have to take procedures now and such to do that. I've felt for them some, because we've had issues with medical doctors and chiropractors being closed, and they've had to fall back on telemedicine and that type of thing. The claims are still proceeding forward. It's taking longer to get the medical records in because, of course, the hospitals sometimes don't have a full staff there and everything else, which I get it. And, of course, medical records are not the top priority. It's keeping people safe, so that's fine, too. It's slowed down that way. The insurance companies are doing a lot of things with the adjusters at home as well. So, again, we're still talking to each other. It's just taking a little longer for them to them to respond, for them to get the records than I do send them, because most things I send to an insurance company go to a scanning center and then have to go on to the individual adjusters. The biggest part that I would say on all that is, again, that's why you want to have all your ducks in a row when you're dealing with your case. Because, again, one of the advantages I've had to this virus is that I have been able to go back and concentrate on certain cases much more so without putting some weekend time in and such like that to really push through some cases that I really wanted to. So that's been great, but you've got to know, again, you got to go back and look. And like one of the things I do every day is sometimes I'll look at my case list and say, I'll question myself, what can I do in this one? Have I given them long enough in the records? Can I pick up the phone and say, hey, can you get this over to me faster? All these little things to kind of keep cases moving forward, because especially now, people are unemployed. So if I can get a personal injury settlement done without sacrificing the value or my client's rights, I want to do it, because, especially now, $1 now is worth, $2.50 3 months from now.
Well, and that's the thing. I mean, the faster you can get to work, the faster, ideally, we can get this thing resolved. But the good news is, you're taking your preventative measures. You've got hand sanitizer. Right. You're visiting clients at their homes if you have to. You're visiting clients at hospitals if you have to. Walk us through that. What are some of the personal things that you're doing? And how has that changed a little bit? And
the visitation and the clients, I've been pretty much trying to feel them out and see what they're comfortable with. But yes, I go out and I have the mask. I have the hand sanitizer before I go out. I have the hand sanitizer, before when I get back in the car and everything else. I'm doing all those procedures. We don't have to do it that way. It depends on what the client wants to do. Most of my business is electronic, and that's why I love using the cell phone, because the majority of my contact with my clients is through text messages and phone calls. So when I get that first phone call, as a matter of fact, if they have the police report number there, we brought up bike crash before in podcasts. I love it because, again, if the police report is ready, you can have somebody on the phone. You can go print that thing up. You can now email to them. Or I can even, if the client gives me permission, even before I meet with them, I can go ahead and send insurance companies letters by facsimile, getting claims open, saying, let's move this thing along. There's 100 different ways to do it. But typically for me, the only 2 times, unless a client wants to sit down and go through things, has been the beginning and the end of a case anyways when I met with a client. So now we just take a little, fewer extra precautions, and we see what they're comfortable with. Do they want to come to my office? Do they want me to go out there? That's up to them. And either way, we're going to have masks and hand sanitizers and keep our distance.
And again, let's stress, it's not that you don't want to see them. You still are very available to see them. But in terms of how a case works through on the personal injury side, there's generally not going to be a lot of direct interaction unless it's within these certain time frames where, again, initial, hey, let's get this going, maybe at the end when you're settling everything. If it goes to court, obviously, you could have depositions and different things, but most of the cases don't go like that.
Yeah, and honestly, I think one of the things, 2 things, I'm going to pat myself on the back. I think 2 things that I do the best on, and it's so damn simple, and I warn clients about this, is I'll send them a lot of correspondence. And, say a Geico sends me a letter, on a case. I'll scan that, and I'll send off a letter. I'll send them the original because I have the scanned copy. I'll say, FYI, Desmond, and I'll put my date down that I've seen that. Yeah. And again, so they know something's going on behind the scenes. And then you combine that with the ability to text me. The one lady I just signed up that we talked about earlier, first thing this morning, she was texting me because the question is, was this other guy insured and whatever his policy limits again? And that information I was not only able to send the other day, but now I was able to respond by text and kind of reassure her, look, we're going to do okay with this. Because, again, her concern is her medical bills are going to be huge and such like that. And, again, where do you get that reassurance? And this is where I have to preach. You get it from your attorney. So, again, I signed up a case 2 days ago, very typical case, nothing special, okay, very little soft tissue case. Again, I won't say who it is. But I'm getting the case. They're letting another advertiser go. He and I took about 10 minutes to try to figure out what it is this advertiser was doing. And the bottom line is he's not moving fast enough. And maybe he is, but he's doing it behind the scenes. So again, if the client doesn't know and get his hand held within that first 30 days or so, they don't know what to think. And again, that's why I say again, back to even a selfish point of view, if I take the time to lay out my game plan for my client and answer those questions, especially that first 30 days when we're trying to get the car taken care of and they see that it's been taken care of and we're getting the medical bills paid, then they're going to trust you all the more down the road. But you got to deal with that attorney directly rather than, when I was with that big TV advertiser, I saw this happen. And it used to drive me nuts, but I understood why it happened. Where, I would be out on a Tuesday and that case would get signed up with a paralegal. So the paralegal will handle the majority of it. I might do a letter here and there, but this client hadn't heard from me. Now, all of a sudden, we got a settlement offer, and it was a lousy settlement offer or something like that. The client's like, this is the first time I've talked to you. Why should I trust you? Okay? And that's back to the procedure. So that's why I say, again, if it's not me, if it's another personal injury attorney, fine. Make sure, 1, you're comfortable with them. 2, they do car wrecks a lot. And 3, they're accessible to you. And if they're not, why the hell are you paying the 1/3 fee or the 40% or more?
Yeah.
So, I get started. That's why the last blog was talking about ranting.
It's the way it is sometimes. I mean, there's an expectation that you have of yourself, and sometimes you wonder, why doesn't everybody do it this way? I mean, it seems like customer service. It seems like doing the right thing at the right time. It's not that others aren't, but you understand that the client needs to be reassured along the way, and that over-communicating that sometimes you do actually is a good way to put that client at ease and let them know that, hey, I've got this, I'm in it, and I'm working on your behalf.
Well, sure, because think about it. Do any of us really ever want to go call an attorney? I don't.
And you are one.
Yeah, if I call an attorney, that means I'm dealing with something I don't know and I don't know how to handle it and such like that. And that's something I don't want to be involved in.
Yeah.
Okay. So unless it's preventive, like drafting a will or something like that.
Right.
So again, if you're already going to be in that position, why not, have that advice, be able to get that advice, to know where it goes. I'll give him a shout out. He's a client of yours too. My divorce lawyer was Louis Winter. Okay.
Yeah.
One of the best things that Louis and I used to do, because again, I did not know family law, is I would say, okay, and he charges hourly, of course, but I'd say, let's sit down for an hour, and I would go through a list of 10 or 12 questions, because now all of a sudden I knew what he was thinking, where are we going with this, what my game plan would be if things went right. Okay, and so that gave me the confidence to trust him to do it. Well, personal injury attorneys are no different. The thing that you have to do, though, is get hold of that attorney and get hold of him and give him, and don't get me wrong, you got to give him a chance to look at your case. So I can have a client call me sometimes and catch me in the car because I use my cell phone. And I'll say, I'm trying to remember if I'm remembering this right. I don't want to make sure I'm not guessing the wrong case.
Yeah.
So either one, I might call him back when I get in front of the computer, or two, because again, I like the cell phone, I can even text him and say, that's what I thought. Here we go.
Yeah.
And I'm going to say this about the cell phone. Here, I'm going to preach for a second to other attorneys if they listen to this. Why the hell don't they use it and advertise it? I have done the cell phone for 15 years now. Okay, you can deal with phone calls and everything else. I had an insurance company email me the other day, and because it's a smartphone, all I did is copy and paste that, send a copy of that to my client through the text. Now the client knows what the response was to their question a day ago without playing telephone tag to do it.
It's so much more efficient, isn't it?
It is. And I don't understand why people don't do it, because they all think, it's going to be either one, they do it and don't advertise it, or two, they think it's going to be too tough. But three, my thing is that I found with my clients is very rarely, maybe twice a year, do I ever have to have a conversation with a client, say, can you not text me on a Sunday night? Most of my clients are great, very respectful about it, understand I can't respond always right away. And it gives you a means of getting hold of them right away. And because again, if I'm picking up the phone to talk to an attorney, chances are, and you saw this really in family law, this is a great area to put it. And Jim's looking at me like I am ranting again, probably. But especially in family law, and I don't do that kind of law, I understand that. But you see that more than anything else, that if you got something developing on a Monday afternoon at 12 o'clock, and you got a question that raises a question for a family law attorney, if you don't hear back from them until that Thursday, chances are that legal question has already been answered, or you've gone on, or you figured out another way around it.
It's been answered by default.
Yes.
In some cases.
Exactly. Yeah. So that's the again, I don't understand this delay, and people say, well, I'll leave a message, I'll do this. Get them on the phone, because you know what? I can always give you my gut reaction to something and double check my file or do something a little different.
Right.
But again, you can't do that unless you can get a hold of your attorney. And again, I'm going to badmouth the big TV advertisers. You can't get hold of your attorney because you got the receptionist, the secretary, the paralegal, and the case manager before you get to the attorney.
Exactly.
And that's just, it's procedurally, it's just asinine. I'm just going to say it up front.
Different way of doing business. Hey, Jim, let's first of all, thanks for your information, your insights on that. I mean, it's an important topic, and obviously people need to know things like this. But we try to end up each of our episodes here with a little section called "So This Happened This Week," and I want to pass along some kudos and congratulations. You did settle a case for policy limits, as we talked about earlier. Tell us about this case. This is one that you had to push a little bit.
Well, and that's the thing. It's not even settled yet, and this is the part that why I thought it was a good illustration for the audience. Because again, it's a very typical case, but my client is still treating. Property damage was good, okay? Car did look like hell, okay? No question this guy had a severe impact. But the other driver only had insurance coverage, again, for that state minimum of $25,000. Well, and my client has underinsured coverage as well. So the point being, again, because I knew the case and I wanted the case in, and I know my client actually is a little bit strained with all this COVID stuff going on. We have about $10,000 to $13,000 in bills, but it's not surgeries, it's not broken arms. It was still enough that I went ahead and collected a lot of the medical records early and sent them on to the other insurance company. And I said, I think my value of my client's case already exceeds the amount of insurance you've got, okay? And this is why. And the short story is they agreed. So now they've offered their $25,000. I have to go through this big, long procedure legally to preserve my client's rights against the underinsured coverage, okay? But I'm going to do that, And his claim is still going to be ongoing because he's still got treatment ongoing. We still got more we can recover from. But the point for the average consumer is two things. One, again, back to your attorney, they better know your case and be aware of it and have it on the game plan because, again, you want somebody who's going to push it forward. If this case had been, if you had been years ago when I was at a big firm, what I would have worried about with this case is the paralegal. I would have said, hey, where does it stand? They would have said the client's still treating. Well, that meant generally you were not ready to settle a case, which is true. But the problem is if you got a limited pot to go for, in this case, limited insurance, go for it early. So yes, what we've succeeded on is we succeeded on recovering what we wanted to on phase one. And because we did that after we jumped through some hoops, we still have a claim that's open under phase two, which is the underinsured coverage I've always preached about.
Wow. And for the client, I mean, that's nice to at least have some money coming in.
Right.
Especially right now, if they're not working, maybe their spouse, if there's a spouse involved, could be not working as well because, again, the whole COVID issue. I'd rather have a bird in the hand today. And
just from a strategy standpoint, think about something here. We weren't on the radar of the underinsured carrier until this just happened.
Yeah.
Now I get to turn my focus over the next 6 months to them and saying, this is why they need to be aware of it. This is why we're going to have a claim, and this is why you're going to be paying out some money. It's just a smarter way to do things. But again, if your attorney isn't kind of observant for those things, it doesn't happen. Now, if it had been switched around and the guy had $100,000 in coverage with $10,000 or $12,000 in bills, no, we wouldn't be trying to settle phase one because we wouldn't be wanting to walk away from money. But if it's a limited pot, your attorney might as well go for it, fast and strong.
All in early. Yep. I'm with you. Jim, buddy, again, I know you're busy. Thanks for your time today. I really appreciate it. And friends, I hope you got something out of this. I mean, it's not often you hear one attorney, talking about a television attorney, but it's a different way of doing business. And I've known Jim for many, many years. We've worked together for many, many years. And as a solo attorney, I know his attention to detail. I know his passion for the business. Hopefully that comes through in some of these podcasts that you may listen to. And he's good at what he does. And if you need help, if you're out there and you're looking for an attorney that is going to know you by name, one that you're going to be able to contact and get a hold of, I encourage you to call my friend. And Jim, what's the cell phone number before we leave?
502-609-7657.
There it is. That's a wrap for this episode. Hey, buddy, I appreciate it. We'll see you back in 2 weeks.
Thanks again.
Take care. Bye-bye. That's it for this episode of the Kentucky Auto Accident Podcast. Jim Desmond will be back in 2 weeks to provide information you need to know related to car accidents and motorcycle wrecks in Kentucky. Until then, check out AttorneyDesmond.com. You can also follow him on Facebook at Attorney James Desmond. Drive safely, and please remember to buckle up.